1983. Dalawang question siya, which is yung number 1. Sa number 1, dalawang question. What is the difference between fiqh and Sharia? And then yung letter B, what is Sharia value o hukum Sharia and what are its kinds? Explain each of them. So ito po yung answer ko, babasahin ko na lang po para dire-diretso na. So sabi doon, sabi dito, Sharia is the body of revealed laws found both in the Quran and in the Sunnah, while fiqh is a body of laws deduced from Sharia to cover specific situation not directly treated in Sharia law. Sharia is fixed and unchangeable, whereas fiqh changes according to the circumstances under which it is applied. Then yung letter B na question, hukum Shari'i is a communication from the lawgiver concerning the conduct of the mukallaf. So nilagay ko din yung mga part, no, yung the hakim, the lawgiver, the mahkum fihi, the actor of the subject matter of hukum, then yung the subject, yung mahkum alayhi, who must capable of understanding or at least receiving the hukum, and then yung rulings. So nalagay din doon, give the kinds of hukum syari'i. So nilagay ko yung dalawa, yung mandatory law or hukum taklifi. It is the characteristic of man's acts, whether they are obligatory, forbidden, commendable, and improper, or which indicates the legal effect of the act. And the second kind, declaratory law or hukum wadi, is nilagay ko Imam Shafi'i defined the declaratory law as communication from the lawgiver which enacts something into cause, the sabab, a condition, the shart, or the hindrance to something else, or the money. Yun yung number 1. Then number 2 na question sa 1983, give the 4 sources of Islamic law or Adila al-Sharia, and then how, where, and when was the Quran revealed? This is my suggested answer. Letter A, Holy Quran, direct ko na, the Holy Quran, the Sunnah of the Prophet Muhammad, peace be upon him, the Ijma, the consensus, and the Qiyas. And letter B, yung how, where, and when was the Quran revealed? I don't know if this is tama, sir. The Holy Quran is a speech of Allah and the book revealed in Arabic to the messenger of Allah, Muhammad, peace be upon him, through Angel Gabriel as written in a Masahif and transmitted to us from him through an authentic continuous narration or tawatur without doubt. Furthermore, Al-Quran is the word of Allah, book of guidance, knowledge, law, religion, morality, art, and sciences. It revealed to the Holy Prophet, peace be upon him, for a span of 23 years, 13 years in Makkah and 10 years in Medina. And then number 3 questions of 1983. Explain the gathering, compilation, or codification of the first, the Quran during the lifetime of Prophet Muhammad. B, Quran under the leadership of Abu Bakr, and number 3, Quran under the leadership of Uthman. So natakil man din natin ito sa ni sir. So yung suggested answer ko, ito na po yun. During the lifetime of Prophet Muhammad, peace be upon him, compilation of Quran is in the heart of the Prophet Muhammad. B, compilation of the Quran by written on any suitable object, leaves of trees, piece of wood, parchment, flat stones, and more. And then yung under naman ng Abu Bakar, sabi doon, letter A, Umar bin Khattab strongly advised Abu Bakar to preserve and compile the Holy Quran. This was prompted after the Battle of Yamama, where heavy casualties were suffered among the memorizer of the Quran. Letter B, Abu Bakr entrusted Zayn bin Thabit with the task of collecting the Quran. Then Zayd had been present during the last recitation of the Quran by the Prophet to Angel Gabriel. And letter C, Zaid, with the help of other companion who memorized and wrote verses of the Quran, accomplished the task and handed Abu Bakr the first authentic Quran, a copy of Quran. And letter D, the copy was kept in the residence of Hafsa, daughter of Umar and wife of the Prophet. And yung sa leadership naman ng Uthman ibn Affan ordered Zayn bin Thabit, Abdullah bin Zubair, Sa'id ibn Ash, and Abdul Rahman bin Harith to make several copies out of the authenticated copy kept by Hafsa. So this was due to the speedy expansion of the Islamic State and concern about the differences in recitation. So it was incited at Battle of Armenia. The Muslim read the Holy Quran in various modes. Therefore, the Caliph Uthman bin Affan resolved the writing of the Quran in one book as the official copy and distributed it to the different region. He also ordered the burning of the other copies scattered all over the countries. Number 4, 1983 question, Sharia bar question. A, distinguish between a hadith and a sunnah of the glorious Quran. Letter B, what are the kinds of sunnah with the respect of his transmission? So this is my suggested answer. Sunnah refers to the Prophet's sayings, actions, and practices, and practical gathered and congregated from the Prophet. It refers also to what he silently and verbally approved, while hadith implies the narration of the record of the Sunnah and also contain historical elements, and it's the story of an eyewitness concerning what the Prophet said, did, or tolerated in connection with certain situation or happenings. While letter B, suggested answer, classification of Sunnah as to transmission. A, it's mutasil, continuous. So yung under niya is mutawatir, or one that is continuously recurrent and reported by indefinite number of people. Then the letter number 2, the mashhur, or one reported by one, two or more companion, or from another companion. And the diffusion of the report must have taken place during the first or second generation following the demise of the Prophet, not later. And number 3, ahad, or one reported by one person. Number 5, question, 1983. A, distinguish between Qiyas and Ray. Di ako familiar sa Ray, sir. Ewan ko, sir, kung natakal natin ito, but nag-research lang ako.
Rai.
Oo. Rai. Then letter B, explain the 4 condition and requisite of Qiyas. So this is my suggested answer. Qiyas is analogical deduction or reasoning. It is the extension of Sharia value from the original case to a new case because the latter has the same effective cause as the former, while Ra'i is to refer to a sound or considered reasoning by individual, where an early Islamic movement advocating the use of reasoning to arrive at legal decision. They were one of the three main groups debating sources of Islamic law in the 2nd century of Islam. The other two being al-Kalam, or speculative theologians, and the Ashab al-Hadith, the partisans of Hadith who eventually prevailed. And then lumabas yung na topic natin na abrogation. Number 6 question, explain the rules of abrogation. And letter B, explain the following principle of legislation, yung istisan, istislab, maslaha, suna of the companion, and custom. So these are my suggested answer. Sabi doon, abrogation or nas literally means transcription or transfer. It is also defined as suspension or replacement of one Sharia ruling by another, provided the latter is the subsequent origin and two are in conflict with one another, and it is not possible to reconcile them, or when the latter express repealed the former. So letter B, sabi doon, i-explain kung ano yung mga principle yung istisan. Lumabas din siya. So istisan literally means to approve or to deem something preferable. It is derived from hasuna, which means good or beautiful. It can be translated as juristic preference. It involves the setting aside of an established analogy in favor of an alternative ruling which serves the ideals of justice and public interest in a better way. Then yung istislab literally means associate. Hub to sir, no? H.
Yes.
Oo. Wait, i-edit ko na lang. Istishab literally means association, escorting, or companionship. The facts proven in the past and are presumed to remain so far as lack of evidence to establish the contrary. The Shafi'i and the Hanbali schools of law sustain on this legal principle. Istishab, hindi ko lang pala na-id. Istishab applies only when no other evidence is available because maslaha means attending and leading. An example of this is everything is recognized to be permissible unless the contrary is proved. And then yung maslaha mursala, it is a method of deduction and reasoning of law based on general consideration of public well-being. This is a legal method which associated with the Maliki school. And then yung suna of companion or the opinion of the Sahaba, either as a group or individually, was considered most important source of law. This source was divided in two parts according to position taken by the Sahaba. If they were united on an opinion, it was preferred to us ijma. And if they had different opinion on a single issue, each opinion was referred to as the, ano nga to siya, Rai. So, or personal opinion. And then yung custom refer to the collective practices of a large number of people, defined as recurring practices which are acceptable to people of sound nature. To be valid basis of legal decision, it must be sound and reasonable. Number 7, dalawang question din. What are the four orthodox Sunni school of Muslim law. Letter B, state and explain the three kinds of mujtahid. So, letter A, the four orthodox Sunni school of Muslim law are the Hanbali, Maliki, Shafi'i, and Hanafi. Kinds of mujtahid are the following. Ay, tatlo. Full mujtahid. This rank is assigned to those who meet all the requirements of ijtihads. They deduce the ahkam from the evidence in the sources, and so doing were not restricted by the rules of a particular madhab. And number two, mujtahids within the school or mujtahid fil madhab. These are jurists who expounded the law within the confine of particular school while adhering to the principles laid down by their imams. Number three, mujtahids on particular issue or mujtahid fil masail. These are jurists who are competent to elucidate and apply the law in particular cases which are not settled by the juries of the first and second rank. Their main preoccupation is to elaborate the law on the fresh point which were not clearly determined by the higher authorities. Ay, nawala. Ayun. So, number 8, may legal maxim siya. Explain the following legal maxims. Number 1, necessities of darura or darura makes forbidden things canonically harmless. Number 2, the smaller of the two harm is chose. Number 3, reward begets risk. So, explain daw yung legal maxim. Hindi ko alam kung tama to. So, sabi dito, yung suggested answer ko, necessities or darurat make forbidden things canonically harmless means that in extreme situation, prohibitive things can be allowed as long as there are no other alternative that can be chosen from. So it is on this basis that the juries validated demolition of an intervening house in order to prevent the spread of fire to adjacent buildings, just as they validated dumping the cargo of an overload ship in order to prevent danger to the life of its passenger. Sabi ni Kamali, 2012. So, number 2, this maxim is a branch of a leading maxim, harm must be eliminated. The meaning of this maxim is that if harm is unavoidable daw, one must choose the lighter harm, as reflective in the maxim that state the lesser of two harm must be chosen. And then yung number 3, the legal maxim reward begets risk and is related to gain begets liability. Benefits and burden is proportional. This maxim means that the man cannot expect to earn a profit without assuming loss or risk in his whatever undertakings. It is a way of life that business is associated with rewards, profit, risk, and uncertainties, according to Rossley 2005. To sum up, this maxim, there shall be no reward without risk taking. Number 9, question. Dalawa din siya. Distinguish between the Hadith Qudsi and the Hadith Qudsi and the verse of the Quran. Hindi ko alam kung tama to. My suggested answer, sir. Hadith Qudsi is as to the meaning of from Allah, as to the wording, it is from the Prophet. It is that Allah has communicated his Prophet through revelation or in dream, and prophet has communicated it in his own word or words. Hadith literally means news, report, or narration. The word hadith means in particular and report verbal or written about the sunnah of the prophet. And hadith consists of three parts: the sanad, the mathen, and the taraf. The sanad or the isnad refer to the chain of narrators that has reported any given hadith. The mathen refer to the actual text of hadith, which is authentic as actual sunnah of the prophet. And the taraf is simply the nickname of a hadith. Number 2, in the Quran, the precise wording is from Allah, while in the Hadith Qudsi is a wording is given by the Prophet Muhammad. The Quran has been brought to Muhammad only by the angel Gabriel, while Hadith Qudsi may also have been inspired otherwise, such as dream. The Quran is inimitable, unique, and protected by Allah, but not so the Hadith Qudsi. The Quran is divided into chapter and verses. There is no such organization to Hadith Qudsi. Hadith Qudsi cannot be recited in prayer as the Quran is. There is a specific reward for reciting each letter in the Quran, while reward for reading the Hadith Qudsi is general. So that's the difference. Number 10, I think last na to. Yeah. Sa 1983. So what are the categories or legislation during the lifetime of Prophet? And then explain the rules of transmission of ijma. Then, can the Muslim Filipinos of today make their own ijma? So these are my suggested answer. The following are category of legislation during the lifetime of Prophet. Number 1, the Al-Aqam Itigadiyya, who's pertaining to faith and beliefs. I don't know if tama to. Number 2, the Al-Aqam Al-Kulukiyya, who's concerning morality and ethics. Number 3, the Al-Kalam Al-Maliyya, who's relating to laws of practical life governing man's deeds and action in relation to Allah and to his fellow human being. Number 4, Al-Ahkam Muamalat or civil transaction, laws relating to protection of Islamic faith, laws dealing with family life such as marriage, divorce, paternity, and more, laws of transactions such as contracts, sales, and more, and Kubat or penal laws, constitutional laws, international laws, and economic social order, which is the PD 1083 ay mafo-fall sa Al-Aqam Muamalat. And then yung Al-Kalam Ibadat, yung religious rituals. Letter B. Ijma is derived from the words jama, means to add, to agree, or to solve. Literally means an agreement upon matter or unanimity of opinion. Means an agreement or consensus of the Muslim scholars of a given generation after the death of the Prophet Muhammad to formulate independent judgment in a legal or theological question based on any of the sources of Islamic law. So it is also defined as the consensus of the Muslim jurists of any particular period concerning the Sharia value. The law laid down by ijma is considered to be authoritative and binding. Tapos may question doon na yung question. Can the Muslim Filipinos of today make their own ijma? I don't know. I said yes. I don't know if tama. Yes, but there are some requirements of acceptable ijma, which are the following. First, the ijma is an exertion among the mujtahid formulating decisions based on the interpretation and application of the Islamic law. B, or number 2, the consensus is made by and among the mujtahid qualified to do so. Number 3, the mujtahids are among the community or ummah of the Prophet Muhammad. And number 4, the consensus is made after the death of the Prophet. And the rules of law agreed upon them is the Sharia value. Ewan ko kung tama yun, sir. So, yun po yung 10 question and parang 20 siya kasi tag-isang or more than 20 siya actually. Yung 1983 kung ano ba. Yes, sir.
Okay. Let's listen first to your classmates before you proceed to the 1999 Sharia Bar examination. Comments. What do you think, guys? Sa mga answer ni Mama Snaira, particularly dun sa presentation ng answer. Maganda. So, remember, although kasi ito ang nagiging dilemma rin, nakita ko rin yung kay Jonas kasi syempre ang background natin is that we're social science eh. Parang kasi Islamic studies. So ito naman ay mga parang legal. So yung pagsagot, yung pag-present ng sagot, dapat at least mahina ba yung audio ko? Okay. Hello. Mahina pa rin ba audio ko?
Okay na, sir.
Wala po, sir.
Okay. So, ayun nga, yung what are your comments dito sa presentation of answer, yung suggested answer of Mrs. Naira dun sa 1983 Sharia Bar examinations? After inyo, tsaka ko sabihin niyo sa akin. So, anyone? Any comment kay
Sir, ako po.
Okay, Jonas, please.
Sir,
at saka kung may hindi rin klaro sa iyo, para ma-discuss natin. Proceed, Jonas.
Yes, sir. And sa akin po kasi yung ibang questions talagang nahirapan ako sagutin. Kaya kailangan kong i-research pa muna. So, I guess hindi siya pang Sharia bar. Yung answers minsan kailangan research eh. So, I guess masyado pong yun nga, sabi niyo nga, social science style yung pag-answer. Meron pa, alam ko, nag-cite pa ako ng mga libro to answer a particular question, which is not practical po kapag nag-answer ng Sharia bar questions. So, yun lang po yung na-note ko din po si Miss reporter po, si Sabit, na nagsasite din siya ng kagaya dun sa isang answer po niya na parang research paper nga po.
Very good. Doon naman sa mga questions, may hindi ba klaro sa iyo na topic na discuss? Doon sa baka hindi natin na-discuss.
Sa akin po siguro, sir, meron po yung mga neo-ijtihad, yung yung po, although hindi ko siya masyadong nakuha sa discussions natin eh. So, okay. Pero yun po yung sa akin po.
Okay. Yung kay Sarip, okay naman, naintindihan naman yung mga yung mga questions na niya, yung mga topics doon sa questions.
Yes, sir, sa akin, opo. Ando naman mga familiar na rin po ako doon sa ibang topics like yung Qiyas, Ijma, yung mga sources of Sharia po.
Okay, very good. So, si Miss Anisa, may any comments doon sa 1983 suggested answers ni Miss Sarip?
Sir, ano po?
May comments ka ba doon or question doon sa suggested answers ni Miss Sarip?
Sa akin lang, sir, sa way lang po nung pagsagot niya, sir, like, parang feeling ko, suggestion ko lang is, much better kung naka-Roman numerical number, yung mga enumerations niya.
At ano pa, doon sa mga topics, sa mga questions, klaro ba yun lahat? O, kung ikaw ang natanong ng mga questions ni Miss Sarip, are you able to at least answer or may idea ka doon sa mga topics na napapaloob doon sa mga questions?
Yung ibang topic, sir, wala rin po akong idea. Pero sa iba naman, sir, nasagot naman niya po based sa mga na-topic natin, like sa mga IJMA, sa KIA, sa schools of law.
Which
Pero
particular topic ang hindi klaro sa iyo?
parang yung sa, ano, sir, number 9 ata yun.
Let's see. Kasi para at least ano na rin natin, no? Pwede natin i-discuss yung mga hindi klaro. Kasi yun nga, gaya ng sabi niyo, yung content, ano naman, so far, okay naman. No?
Opo.
Pwede pang enhance at saka pwede pang ano. So, yes.
Yes, sir.
Number 9. Alin dito? Itong Hadith
Yung
Qudsi?
number 9, sir. Yung Hadith Qudsi, sir, parang hindi ko siya maalala. Wala naman po akong comment sa sagot ni Ma'am Asnaira kasi maganda yung sagot niya, pero yung parang way lang, sir, ng pag-present, parang feeling ko mas okay siya kung naka-Roman numerical, yung enumeration. Yun lang talaga, sir, yung comment ko lang po. Pero maganda yung mga sagot niya po.
So, alhamdulillah. So, Hadith Qudsi, actually, parang hindi nga natin ito nadaanan or nadaanan very, very brief lang siya. No? Okay, so I'll discuss that later on. Ano natin, no? Ano bang pagkakaiba ng Hadith Qudsi and Hadith. Actually, yung answer naman mostly ano siya, correct? So, i-clarify lang. Expound lang natin ng konti. Ano bang Hadith Qudsi? What's the difference between Hadith Qudsi and a regular Hadith? And what's the difference between Hadith Qudsi and a verse from the Quran? Okay, so we'll get back to that later. Si Mr. Sarip, any questions?
Hello sir. Sa akin po wala naman. Most of the questions naman po is parang familiar naman po sa mga naging topics natin, and so far sa mga answers naman po ni Ma'am Sarip, wala naman din po akong masyadong maging comment.
Alhamdulillah. So kung ganun, at least yung mga topics medyo na-discuss natin. Lastly, si attorney, no? So si attorney talaga ang ano natin, paano ba dapat ang suggested answer? Baka may marami tayong matutunan kay attorney.
Actually sir, gusto ko rin magtanong, pero with regard po doon sa presentation po ni Ms. Sarip, okay naman po yung pag-present niya sa Q&A. Gusto ko lang pong itanong yung napansin din ni Mrs. Naira, if yung question po pa talaga, yung regarding doon sa Istis Hub at saka yung Istis Lab, gusto lang itanong if halimbawa ay ang original question po talaga is Istis Lab. I mean, paano kaya, kasi malalaw kasi sir, before parang meron din question na parang ganito na may clerical error. If I'm not mistaken, yung parang instead na taklifi, parang nakasulat sa questionnaire is takufi.
Takufi, yes.
Oh yes, kaya gusto ko rin tanong Ustad kung ano bang magandang way for purposes of taking the bar, kasi maraming hindi magtitik dito. I think ano kaya magandang kung halimbawa kapag merong istislab na hindi natin nadaanan, I mean medyo may pagka-strange kasi nga iba nga yung pagkasulat. Are we going to answer it yung medyo in nearest kagaya ng, kaya gusto ko i-clarify kung ang question ba talaga na originally written is this lab ba or medyo kan lang yung clerical lang sa pagsulat. Kasi nangyari yan din before, kaya gusto ko rin i-kuan. Ano po yung thought nyo, sir, if paano siya i-answer kapag may mga ganong pagkasulat na parang hindi familiar sa mga doon sa magte-take or mag-answer ng questions. Yun lang, sir, ang kunting ko.
Thank you, no. Actually, yan nga ang isang problema, no. But yung gaya na sabi mo, no, kami mismo naka-experience nun, yung taklifi at saka takufi. So me, kasi you can there's no words such as takufi. So kahit anong gawin natin, wala tayong may sasagot. So pinakamalapit talagang taklifi 'yon. No? So yun ang sinagot namin, taklifi. Me personally, yun ang sinagot ko, taklifi. At ganito rin sa pag hindi talaga maintindihan, unless yung word na yun ay na maintindihan, no? May isa pang I remember bar question din, no? So ganun din, define or ano mga meaning na itong mga words na to. Tapos may parang kakaiba sa lahat, no? Parang nasama ata yung itiba ba yun o hiba o so yun ang isang nung nire-review rin namin yun, sinasabi na ito baka mas bagay dapat dito yung hiba kasi siya yung related doon sa lahat ng mga listed na pero kung titingnan may word din na itiba. So pag ganun ang dilemma, yun ang mas no. So but we answer kung ano yung nandun na tanong kahit hindi siya related, parang related doon sa question. Kapag hindi talaga maintindihan, katulad ng isang example, yan, istislab, kung yan ang nasulat, ewan ko ano bang istislab sa pagpapatigas. So mahirap solve ano bang niyan. Meaning niyan, no? So yun ang yan ba yung minimin, pero makita mo naman kasi sa context ng question. So mga Islamic principles. So clerical, pag clerical as much as possible yung sa akin, no, sarili kong opinion ay ano yung talagang Islamic principle na dinidiscuss. So yun, istishab.
Ako,
Thank you,
sir,
sir.
may comment ako.
Yes.
Sa
Oo nga,
akin.
yun nga, ikaw ang last na tatanungin ko ano yung hindi klaro sa'yo at ano ba yung ano mo. Yes, Miss Sarip.
Napansin ko, sir, medyo matataas yung answer ko. Parang doon sa training ng Sharia last September, na-remember ko, dapat precise, dapat pala magsagot.
Brief.
Tapos, brief lang siya, tapos direct. Pansin ko sa mga sagot ko, parang ang dami siyang words. So, parang ayaw na na-imagine ko kapag mag-check yung examiner, ayaw na niyang basahin lahat. Ganun, sir. Parang yan yung dapat ko iwasan pala, sir, na dapat precise at saka brief lang na pagsagot.
Okay. Yun, but yun, as sabi rin ng mga mga lawyers din, no, tsaka yung mga law students, sabi nila actually depende daw sa kung anong ilang points yung question, no. So kung ang question ay may malaking points, for example 10 points, so talagang magdi-discuss ka ng mahaba doon, no, as much as possible, no. Kung ang points naman niya ay 0.5 or 1, so as brief, no, yun daw ang doon daw nakadepende. I'm not sure kay attorney, no, kung tama ba yung ganun ba?
Ustad, pwede magtanong?
Yes.
Ano pong sa tingin niyo po, sir, is it recommended, sir, na mag-set ka po ng parang halimbawa lalo sa subject na jurisprudence or ibang bar subject, is it recommended, sir, that you cite like yung mga Arabic, kasi yung mga basis, kasi may narinig kasi ako na may mga previous daw na maraming mga Quranic basis daw ang lumalabas, tinatanong na parang yun daw ang parang kailangan isagot mo. Is it really kuan? Do you have to answer the Arabic text yung in its original form, or pwede yung transliteration lang ng Arabic text then you will translate, or will it suffice na yung translation lang po ang isasagot? Ano po yung mas maganda sa tingin niyo, sir?
Ang sabi kasi nila, no, when you're answering, kasi 'di ba dalawa, you can choose any of the two language sa inyong exam, English or Arabic. So if you're answering in English, as much as possible, wag daw magsusulat ng Arabic kasi baka marking daw 'yon. Yun ang ano. So if you're asked for a Quranic verse, so you have the option, no, kung diretso ka na sa translation or mag-transliterate ka muna. So for example, lang isa-cite mo na ano, may aya, no? So isulat mo at least yung pinaka ano yung shahid, ano yung pinaka-importante doon na gusto mong i-mention na basis mo. Then transliterated, then you translate it. So kung ako ang ano, ganun ang hanapin ko sa sumasagot ng English. Pero kung siyempre, kung Arabic yun, dapat ma-cite niya talaga yung buo, yung verse mismo, yung aya mismo.
So ibig sabihin, sir, kapag mag-take ka ng in English way of answering, avoid na lang yung Arabic, sir, na something like that.
Yes, yung mga Arabic text, yung Arabic script mismo. So i-avoid yun, no? Arabic script.
Thank you, sir. Thank you.
Fun. Okay, so doon sa ano yung concern ni Sarip, Miss Sarip. So yun, no. Yung presentation din ng answer, wag naman yung masyadong ano, very concise na ano. So yung mas maganda ata yung paragraph form, no, na pag-answer kaysa minsan palaging ano, enumeration. So depende. So kung enumeration ng hinahanap, pero yun nga, paragraph form at saka you start your answer, no, ng may opening ka at saka ano. Anyway, yung mga sagot naman as long as nasa tamang ano, yung tama yung concept, may points yan. Okay, doon naman tayo sa ano. So klaro lahat yung mga tanong doon na Miss Sarip, no, lahat ng topics. So i-discuss lang ng konti yung ano ba yung Hadith Qudsi, no. So Hadith Qudsi is a type of hadith, no. So it is actually a hadith, no, kasi ito ay kasama sa pwede nating i-consider na saying ng Prophet Muhammad sallallahu alaihi wasallam dahil yung wording niya is from the Prophet Muhammad sallallahu alaihi wasallam. So ang pagkakaiba lang is he is narrating what Allah has inspired him. For example, the Prophet sallallahu alaihi wasallam said, Allah subhanahu wa ta'ala says like this. Yun, no? Pag yun ang pamamaraan ng pagka-narrate ng hadith o pagkasabi, so most likely it is a hadith qudsi. No? Kung hindi ito aya, kung hindi ito verse sa Quran, ito ay hadith qudsi. Kasi mapapansin nyo na parang the Prophet Muhammad sallallahu alaihi wasallam is narrating something that Allah subhanahu wa ta'ala said, but it is not part of the Quran. So yung meaning daw ng hadith qudsi is from Allah, but the wording is from the Prophet Muhammad sallallahu alaihi wasallam. Unlike the Quran, the wording and meaning, the precise wording and meaning of each verse in the Quran is from Allah subhanahu wa ta'ala, and it was revealed to the Prophet Muhammad sallallahu alaihi wasallam through angel Gabriel, no, Jibril. So yun yung pagkakaiba ng Hadith Qudsi at saka ng Quran. And yun nga na-mention din ni Miss Sarip na you can read the Quran in the prayer, but a Hadith Qudsi cannot be read in the prayer. No? Hindi kasi siya ay Hadith, no? Hindi siya Quran. So hopefully medyo klaro yun, no? Yung pagkakaiba ng Hadith Qudsi at saka ng Quran. So yung Hadith Qudsi, it will still undergo scrutiny like any other hadith. So if it is ano yung number of yung chain of narrators niya, check siya na ba siya mutawatir, siya ba ay mashhur, aziz or ahad, siya ba ay sahih. Kung hindi siya mutawatir, kung siya ay ano lang hadith ahad, so siya ba ay sahih, siya ba ay hasan, siya ba ay daif. So maraming mga hadith qudsi na daif actually, no. So yun ang kanyang classification. So unlike sa Quran naman ay hindi na, no, automatic when it is said that it is a verse from the Quran, so automatic yan. All of them are mutawatir. All of them are transmitted to us through a continuous and numerous, no, chain of narrators. Okay, so hopefully klaro yun, no? Okay, so kung wala nang ibang tanong, let's proceed, no, si Miss Sarip, para next ay si Jonas na.
Ayan. So maraming salamat po mga kaklase and mga classmates and sir, na take note ko po yung mga recommendation. Now let's proceed to 1999 Sharia bar examination on Islamic jurisprudence and customary law. Napansin ako, medyo pabalik-balik yung question na iba. So, i-ano ko lang siya. So, yung number 1, define or explain the following terms. So, Islam, Sharia, and fiqh. These are the suggested answer. Islam, religion of voluntary submission to Allah's will, obeying of His commands without at least objection. It covers all aspects of life, including the life after death. It deals not only the relationship between Allah and man, but between man and himself, and between man and others creatures of Allah. Then Sharia literally means a water hole where animals gather daily to drink, the road to watering place, or the straight path or way. It is the name given to the totality of God's commandments. It is defined as that which would not be known had there not been a divine revelation. It referred to a sum total of Islamic laws which were revealed to the Prophet Muhammad and which are recorded in the Quran, as well as deducibly guided lifestyle called Sunnah. And fiqh literally means the true understanding of what is intended. So the Prophet Muhammad said, to whosoever Allah wishes good, He gives the fiqh or true understanding of the religion. Fiqh also is the deduction of the Sharia values relating to conduct from their respective particular evidences. And it is also scientific studies of elucidation on Sharia. And it is the knowledge of right and obligation from Quran and Sunnah. And it is the knowledge of all the rules and commandments of Islamic law, which are practical in daily life and derived from detailed proofs of law. Number 2, what are the primary sources of Islamic law? Discuss each briefly. So, yung apat na primary sources. This is These are my suggested answer. The primary sources of Islamic law are the following. Number 1, the Quran, the Holy Quran, kasi i-explain mo siya briefly daw. So the Holy Quran is a speech of Allah and the book revealed in Arabic to the messenger of Allah, Prophet Muhammad, through Jibril as written in the Masahif and transmitted to us from him through an authentic continuous narration or tuwata without doubt. The Sunnah of the Prophet Muhammad literally means a path or a way or a manner of life. It is actual explanation and practical demonstration of the Holy Quran. Technically, it refers to the sayings, actions, or deeds, physical attribute, and manner of Prophet and action of his follower, which he approved. Then the ijtihad literally means intellectual striving or self-exertion, which entails a measure of hardship. The intellectual exertion of a jurist in order to infer with a degree of probability the rules of Sharia from their detailed evidence from the sources. The person who exercises ijtihad is called a mujtahid. Then the ijma, the unanimous agreement of the mujtahidin of the Muslim community of any period following the death of the Holy Prophet on any matter. It applies to all juridical, intellectual, customary, and linguistic matters. It is based from nusus of the dependability of the Ummah. It begins with personal ijtihad of individual juries and ends in the universal acceptance of a particular opinion over a period of time. Differences of opinion are tolerated until a consensus arises. So there is no compulsion or imposition of ideas in the process. Number 3 question of 1999, give the distinction between the following. The God's law from man's law. So these are my suggested answer. So the following are the distinction between God's law and man's law. Islamic law is a complete, perfect, and covers all aspects of human life. Sharia is a permanent for all people all the time. It does not change with time and condition. Allah's law are all nations, all countries, and for all time, it is a universal. While man-made laws are not permanent, they can be changed according to the time and circumstances. Men may make laws when they feel the need. Man-made laws may be suitable for particular nation or country. They can be universal. Number 4. Question, the Holy Quran contains 104 chapters or surah, and Muslim jurists have classified or categorized them into 5 categories or subject matters. What are these 5 categories or subject matters? Describe or discuss each briefly. Actually, na-repeat na siya, parang iniba lang yung way of sa 1983. Paano lang siya gi-present yung question. So the following are the categories, yung the al-ahkam itiqadiyya, yung those pertaining to faith and belief, the al-ahkam al-kulikiyya, who's concerning moralities and ethics, the al-ahkam al-maliyya, those relating to laws of practical life governing man's deeds and action in relation to Allah, to his fellow human being, and al-ahkam muamalat, yung civil transaction, at saka yung al-ahkam ibadat. Then bumalik na naman yung question, distinguish from each of the following, yung hadith qudsi at saka yung ordinary hadith. So, in-explain ni Sir kanina, pero nirepeat ko lang yung answer ko sa taas.
Okay. Continue. Skip mo na yung mga naulit.
Opo. And then ito, give the distinction of the following, the shura from ijma. Di ko alam sir kung na-tackle natin to pero na ano siya. So distinction lang naman. So ijma and shura may be distinguished as follows. Ijma is a legal tool for producing legal rules based on the consensus of legal experts, while shura is merely consultation with people who may or may not be experts in law to derive their opinion to a particular question or affair. And ijma produces rules which must be followed, whereas the result of shura does not always carry the mandatory effect of law.
Okay.
So,
So klaro yung shura. Actually yung and if we have if you can remember when we are discussing the history of Islamic legislation or the development of fiqh, shura is it is the process, no? Ito yung one way o yung naging pamamaraan to come up with ijma, di ba? The Sahaba, the Caliph, no? Will call all the Sahaba, particularly yung mga fuqaha, yung mga ulama, yung learned sa mga Sahaba. So he will, the Caliph will call them, then they will have consultation. So ang result ng consultation na yan, either maging ijma, so there's a consensus. Pangalawa ay kung hindi magkakaroon ng ijma, magkakaroon ng yung majority of opinion, usually nang kukunin ng caliph. So kung walang majority, parang talagang there's really a very large difference of opinion, talagang hati. So pipili ang caliph sa kung anong sa tingin niya ang mas tama. So yung kung anong pinili ng caliph na hukam, yun ang masusunod. Yun ang magiging i-adapt ng state. Okay.
Okay.
Continue.
So, thank you, sir. Medyo nalinawan na ako ng konti din. Number 7, who was the 4 rightly guided caliphs? Discuss briefly their respective contribution in the propagation of Islam. So, yan. Suggested answer ko, the 4 rightly guided caliphs and their contribution on the propagation of Islam. First is Abu Bakr. So, nilagay ko yung time niya. Reign 632 to 634. So, launched the Rida War in 632. He united the entire Arabian Peninsula under Islamic rule and also part of Syria and Iraq. Though the period of this caliphate covers only 2 years, 2 months, and 15 days, it includes successful invasion of 2 most powerful empires of that time, the Sassanid Empire and the Byzantine Empire. Approximately one of the first man to accept Islam from the beginning of Muhammad's prophethood. Then yung kay Umar, he was an expert Muslim jurist known for his pious and just nature, which earned him the epithet al-Furuq. He built up the efficient administrative structure that held together his vast realm. He organized an effective intelligence network, one of the reasons for his strong grip on his bureaucracy. He successfully ended Byzantine and Sassanid rule in the Middle East. Under his rule, Caliph reached control Persia, Khorasan, Egypt, and part of North Africa. And Uthman reigned 644 to 656. Under Caliph Uthman reign, the caliphate reached its heights. Caliphate became very prosperous and the military campaign under the Uthman rules were generally successful. And last, Ali reigned 656 to 661. He was the chief judge of Caliphate under Umar's reign. He was also one of the advisors of Uthman. After Uthman died, he was elected as the next caliph. And later period of his reign coincided with the Battle of Siffin, considered the first successor to Muhammad by Shias Muslims. And ito, I think last na to, yung differentiate the following terms, the ijtihad from taqlid. Ijtihad literally means intellectual striving or self-exertion, which entails a measure of hardship. The intellectual exertion of a jurist in order to infer with a degree of probability the rules of Sharia from their detailed evidence from the sources. While taqlid is derived from kulada or kalada, which is an ornament tied around the neck like a necklace, or it is a strap that holds the sheath of the sword, is usually swung around the shoulder. So it is used to refer to the action to those who lavishly follow a single madhab, regardless of errors that they see. So means the following of the learned without knowledge of the authority for such opinions. So this referred to blind imitation. Natakal ato yata ni Sir. The doctrine of taqlid is considered the duty of adopting the exposition of law as made by early jurists. In other words, a person is said to resort to taqlid when he does not exert his own analytical deduction in order to arrive at a rule, but simply follows an existing rule formulated by others. Ibn Humam and Ibn Nuzaym both define taqlid thus, taqlid is to follow the opinion of a person whose opinion is not approved in Islamic law without asking for his or the person followed proof. Yun, sir. Doon lang po. Yun lang yung question ng 1999.
Walang 9 at saka 10?
Wala, sir. Wala akong ito lang yung nakita ko.
Double check mo. May 10 yan.
Opo.
9 and 10.
Sige po, sir.
Okay. So thank you very much, Mr. Rip. Dito sa 1999 questions, any comments? Question? Mayroon bang hindi klaro na concept or topic dito?
Ako, sir, may napansin po ako. Yung propagation ng Islam, sabi ko, kailangan pala din, medyo malawak pala, sir, may possibility pala, sir, na magkuha sila ng question. Like,
tama.
parang,
No, napakalawak ng Islamic jurisprudence. That's why you cannot really talagang sabi mong napag-aralan lahat. More on talagang palaki na lang yung reading. But the most important thing dito sa Islamic jurisprudence is that you build your foundation. Yung mga basics dapat master mo na, gamay mo na. So that whenever there's a question outside what you have learned, you may be able to infer some answer, no? Kasi meron ka ng foundation, yung basic. So, yun lang. Kasi hindi mo talaga masabi na mababasa mo lahat ng topics. May mga iba pang question dyan na related sa mga different na mga sekta. So, malawak masyado. So, what you can only do is that you read kung ano mga yung basic, then you add yung kung ano yung mga lumabas na, then you go you move from that, mag-add ka na lang. Okay, yung dito, no, so again, no, as much as possible, i-ano mo lang kung kayang depende sa points, no? So kung kaya mo pang i-brief, pa-explain yung sagot mo, mas maganda para mas brief siya, mas klaro, direct to the point. Hindi yung ano lang, mahaba at saka minsan roundabout. Okay, so may iba pa bang tanong? May hindi ba klarong konsepto rito? Si Jonas, may tanong ba?
Sir, may tanong lang ako doon sa primary sources ng
Yes, very
Sharia.
good.
Sometimes po kasi sa ano natin, nasasama yung alam ko Quran, Sunnah, then Qiyas. and then yung ijma. Pero minsan po ijtihad instead of qiyas. Okay lang po bang mapalitan yung, although similar naman kasi siguro, kasi you have to go through ijtihad to produce qiyas po.
Very good question, no? Kapag ganito, no, very open yung ano niya, yung tanong niya, what are the primary sources of Islamic law? Hindi niya sinabi what are the 4 sources, what are the 2 sources, or 2 primary sources. So walang ano, no, hindi siya kinu-qualify na sa number kung ano yung sa primary sources. So you may, no, you may answer, no, may sigurado may points yan pag nasabi mo yung Quran and Sunnah. So yung patungkol naman dun sa qiyas at saka ijma, as we have discussed before, no, these are actually manifestations of ijtihad kasi before you come up with qiyas, yun nga dadaan ka sa, it is a form of ijtihad. Yung ijma ganun din kasi ijtihad yan ng mga particular mujtahidon on a particular generation after the death of the Prophet Muhammad sallallahu alaihi wasallam. So you may answer, if I will be the one who will be asked with this question, I'll answer with the Quran and Sunnah, then ihinto ko na lang dun sa ijtihad. But under ijtihad, sa discussion ng ijtihad, I will mention yung mga yung manifestation o yung forms ng ijtihad gaya ng qiyas at saka ijma. Very in particular yung qiyas at saka ijma kasi sila nga yung sinasabi natin na there's a general agreement regarding their authority and validity, no? So it depends sa Jonas, no, sa ikaw, sa kung anong gusto mo at saka sa, kung ikaw naman ay nagtitake ng exam ay sa oras at saka yung points na binibigay kasi yun palagi ang consideration mo eh. Wag, lalo na pag limited yung oras, ay wag malaking magamit mong oras doon sa maliit na points.
Sure.
Okay, so let's proceed with Jonas. Kung wala na kayong ibang tanong, may ibang tanong ba? Si Mr. Sarip, si Miss Ayunan.
Wala na po, sir.
Okay, alhamdulillah. So, klaro. So, yun lang, Miss Sarip, no, yung mga comments, lalo na sa presentation. Enhance mo pa. Tapos, yun, mag-ingat din sa mga pagsagot, no, yung concepts. Unless, no, yung question mismo ang mali sa spelling, no, dapat wag kang magkamali rin sa spelling. Okay. So, let's
Yes,
proceed
sir.
with
Thank you po.
Jonas. Welcome.
I-send ko na lang to sir sa chat, sir, para ma-download din ng mga klase.
Sure.
So, good afternoon po. Ang in-assign ko po ay sa sarili ko is yung 1993-1995 Sharia Bar questions. Ito po yung mag-start po ako dun sa 1993. Tig 10 questions sila by the way. Tapos ito po yung mga suggested answers ko. Ay, kita na po ba yung screen ko? So,
Yes, we can see it.
So first yung question number 1 sa 1993. Define the meaning of the following terms both as to common use and legal terminology. Letter A, fiqh or Islamic jurisprudence. So what I did to answer is basically define yung fiqh, which is an Arabic term meaning deep understanding or full comprehension. Tapos I proceed to the technical definition, which refers to the body of Islamic law extracted from detailed Islamic sources. And then I also cited yung definition ni Ibn Khaldun sa fiqh, which is knowledge of rules of God which concern the actions of persons who own themselves connected to obey the law, respecting what is required, sinful, recommended, disapproved, or neutral. So, yun po yung pagka-answer ko doon. And then also still in number 1, letter B yung Sharia naman or Islamic law. So same way of answering. I answered first do sa linguistic meaning niya ng Sharia, which is the straight path and the path to watered place or holy or animal stream. And then yung technical definition, Sharia means laws that are prescribed by Allah upon his servants through the tongue of the messenger among his messengers, or simply the totality of Allah's commandments. Because I added a note here that the difference between Sharia and Islam is by stressing that prophets have the same religion but have different Sharia. So that's number 1. Number 2, what are the sources of Islamic legal history and legal culture? Nagkamali lang ako dito, wala na po yung Sharia or Islamic culture. Ang answer ko po, there is unanimous agreement among scholars of Islam that Quran is the main source of Sharia, and there's also unanimous agreement on Sunnah being another source of Sharia. And then after that, I mentioned that there is a general agreement that Qiyas and Ijma are sources, in such that there's also different differences of opinion on how Qiyas and Ijma are specifically done. So there are also other sources of Sharia, which I mentioned here: Istisan, Maslaha Mursala, Istishab, Sharman Keblana, Urf, and Ada, Fatwa of the Companion, and Sad al-Darai. So, and number 3, third question, I think this is a 2-part question as well. First is explain the doctrine of Ijma as a source of Islamic law and its origin in Quranic verses. So first I explained what Ijma is by defining what Ijma. So it is among the rational proof of sources as compared to the Quran and the Sunnah, both of which are divinely revealed. And then Ijma is derived from Jama or Ajma, meaning to add or to agree or to resolve. Hence, it means unanimity of opinion or agreement upon matter. And then from the linguistic point of view, it may mean to decide, to agree. And then I cited the Shafi'i scholar as Sarkashi, defining it as a unanimous agreement of mujtahid scholars of the Ummah of Muhammad after his death concerning some issues at any particular time. And then I also included other definitions, which was also discussed in our class. So yung first, yung consensus of Muslim scholars of a given generation after the death of the Prophet Muhammad to formulate independent judgment in a legal or theological question based on any of the 4 sources of Islamic law. And then the unanimous agreement of mujtahids of Muslim Ummah of any period following the death of the Prophet on any matter. So hindi ko na sinama pala yung 4 points para umikli na. Kasi may 2-part yung question, may origin pa ng Quranic from the Quranic verses. So I said that there's no clear basis in the Quran for Ijma, but jurists have cited the following ayah to justify Ijma. First, Al-Nisa, chapter 4, verse 59. O you who believed, obey Allah and obey the messenger and those in authority among you. And then um, ito yung explanation ng verse na yun. And then I also cited Imam Shafi'i when he was asked to quote the authority of Ijma. He said that he cited Surah An-Nisa, verse 115, and whoever shall opposes the messenger after guidance has become clear to him and follows other than the way of the believers. We will give him what he has taken and drive him into hell, and evil it is at a destination. So may explanation din kung ano yung surah na pina-pertain dito. So the second part of number 3, the third question, explain the doctrine of quasi-abrogation as it relates to ijma. So very complicated for me yung question. But I researched na merong certain times na yung rules of nask or abrogation applies to ijma. But it was mentioned that the rules of nask are not relevant to ijma in the sense that ijma can neither repeal nor be repealed. And the majority view, they said that ijma themselves are entitled to repeal their own ijma and to enact another one to its place. But once an ijma is finalized, especially when all of its constituents have passed away, no further ijma may be concluded. And then there's another belief that a subsequent ijma may abrogate an existing ijma when the former is founded on public interest, as when public interest ceases to exist. So yun po yung explanation ko doon. And then the fourth question, explain, also a two-part, I guess, explain the doctrine of qiyas as a source of Islamic law and its origin in Quranic verses. Very similar to sa question ng ijma earlier, but this time qiyas yung tinatanong. So same thing, I define what qiyas is. Well, qiyas literally means measuring or ascertaining the length, weight, or quality of something, which is why scales are called miqyas. And the technical meaning, extension of Sharia value from an original case or asl to a new case because the latter has the same effective cause as the former. So, and then yung origin in Quranic verses, I mentioned that there are no clear authorities of qiyas in the Quran, but scholars quoted several proofs from the Quran and Sunnah as well as practice companions as an indirect evidence to support the utilization of qiyas. So the following, the two ayahs are those that were used to justify qiyas. First is the Surah An-Nisa, verse 59, and then the Surah An-Nisa, verse 105. So as shown, yan po. And then yung second part ng number 4, letter B, what are the 4 pillars of qiyas in reference to similitude as a juristic basis for reasoning by analogy as far as the Hanafi school of law is concerned. So, ito po yung answer ko doon. I just enumerated yung 4 pillars of qiyas, which are yung asal, yung far, yung illa, and then yung hukam. And then I explained that the Hanafi definition of qiyas is substantially the same, albeit with minor addition, which is designed to preclude certain varieties of qiyas from the scope of qiyas. And then si Sadr al-Sharia defined qiyas as extending the value from the original case over to a subsidiary by reason of an effective cause, which is common to both cases and cannot be understood from the expression alone. So, nirelate ko lang po yung four pillars of qiyas dun sa views ng mga Hanafi jurists. Ito naman po yung sa ibang jurists other than the Hanafi. And then number 5, explain the doctrine of istihsan as it relates to the following views. So, sa madhabs to, itong yung 4 schools of thought. First, yung Maliki, sinabi nila sa istihsan, they defined it as the attention to public interest and justice, and but they lay greater emphasis on istisla. And then they viewed it as a broad doctrine, less stringently confined to the Quran and Sunnah. And then Ibn al-Arabi said it is to abandon exceptionally what is required by the law, because applying the existing law would lead to a departure from some of its own objectives. So that's for Maliki. For Hanbali naman, ang istihsan was said to have subscribed to, according to Ibn Taymiyyah, who is an Hanbali scholar, istihsan is the abandonment of one legal norm for another which is considered better on the basis of the Quran, Sunnah, or consensus. So, dinikit pa rin nila yung istihsan sa Quran and Sunnah for the Hanbalis. For the Hanafis, they regarded istihsan as a principle which authorizes departure from an established precedent in favor of a different ruling for reasons stronger than the one obtained in that precedent. So, very similar lang din dun sa Maliki. And then for Shafi'is, they disagree, saying that he who practices preference assumes unto himself the power of lawmaking. And then Imam al-Shafi'i thought that using istihsan is equivalent to making new rules, which is not permissible accordingly. And then give the Quranic justification of istihsan. I cited some verses here. Al-Zumar 39 verse 18, and give good tidings to those of my servants who listen to the world and follow the best of it. And to those are the ones God has guided and endowed with understanding. And then second one, those who listen to the word and follow the best of it are the ones that Allah has guided, and those are people of understanding. So it was mentioned previously during one of the reports that the word asahanu, asanahu, is the one pertaining to istihsan here, or the root word for hasuna. And then another connotation to justify istihsan is Surah Al-Baqarah, verse 185. Allah intends for you ease and does not intend for you hardship. So pertaining to the concept of istihsan, wherein we're trying to move away from a ruling that will cause hardship. And then 3 examples of istihsan, still in number 5. First, the example, I called this examples from our studies, from our class lectures then. So first example of istihsan is, it is prescribed when death approaches you, if he leaves any assets, that he makes a bequest to parents and relatives. So this represents an exception to a principle that a bequest is not valid since it is tantamount to interference in the rights of heirs. However, the Quran favors an exception which contemplates fairness, especially in cases where a relative is destitute yet excluded from inheritance. So, although may ruling na nga na you cannot make bequest to your parents and relatives, is the son will come in when you make an exemption to that rule. And then the second example, the wakaf of cultivated land includes the transfer of all ancillary rights, such as right of water, passage, and flow. And if these are not mentioned in the instrument of, even if these are not mentioned in the instrument of wakaf. So if it is a rule of the law of contract, including sale, that the object of contract must clearly be identified. But drawing analogy between sale toward wakaf would limit the contract if attached rights are not explicitly identified. So basically, hindi magagamit daw yung wakaf kung susundin yung rule of law of contract. So, in your application ng istesan here. And then the third example, istesan validates a transaction despite the fact that the object of contract is not existent at the time the order is placed, such as when someone places an order with a craftsman or certain goods to be made. So that's it for number 5. Number 6, explain the principles of istishab. Istishab, known also as istishab al-hal, as a source of Islamic law, and give 3 examples. So natakal din natin yung istishab previously, and we defined it as simply as presumption of continuity, which denotes a rational proof which may be employed in the absence of other indications, specifically those rules of law and reason whose existence or non-existence has been proven in the past and are presumed to remain so for lack of evidence to establish a change. So basically, ito yung presumption of continuity. Tanong na sa atin ay pinapa-explain lang yung principle na to. So I cited Shafi'is and Hanbalis, wherein they said istishab denotes continuation of that which is proven and the negation of that which had not existed. So for the 3 examples, number 1, yung purchase of hunting dog. A purchase a hunting dog from B with the condition that it has been trained to hunt, but A claims that the dog is untrained. A's claim will be acceptable under istishab unless there is evidence to the contrary. For istishab maintains the natural state of things, which is the absence of training. So second example, if the nature of the situation is such that no other proof of Sharia could be employed to determine the question of life or death of a missing person, istishab will presume that he is still alive. And then for the third example, legality, as to the legality of a particular kind of beverage or food, there is no other evidence to determine its value. Recourse may be had to istishab, which will presume that it is permissible. So as a general rule permissible lahat, unless there is a ruling that would say it is not permissible. And then for number 7, distinguish the terms urf and adat, and then give at least 3 distinctions. Okay, at first, I said that urf and adat are largely synonymous, and the majority use them as such. However, some distinguish the two, holding that adat means repetition or recurrent practice and can be used with regard to both individuals and group. So Ang note dito is habits of individuals are their personal adat, but we cannot say that personal habits of individuals are their earth. So, and then I proceed to the definition. It is the collective practice of a large number of people that is normally denoted by the earth. And then habits of few or even substantial minority do not constitute earth. So the distinctions first, literal meaning, adat is custom or habit, while earth literally means to know. And then adat refers to individual habits, while earth denotes a collective practice of a given society. And then ito medyo pinilit ko na lang yung third distinction. Adat is not restricted in terms of use and practice, but earth must be compatible with the Sharia to be recognized as such. And then because of that, may mga examples din ako do sa earth and adat, still in number 7. So the Hanafis made use of earth to justify the charging of a fixed price for entry to public baths, even if the unknown quantity of water used is anomalous to the requirements of sale. So that's the first example. Second is the Al-Shaybani validated the sale of honeybees and silkworms as commonly practiced during his time, despite the analogical ruling or qiyas Abu Hanifa had given against it on the grounds that they did not amount to a valuable commodity. And then the third example, earlier ruling from Hanafi said that no one was allowed to charge fees for teaching Quran or principles of faith for teaching them is a form of worship. And then subsequent experience showed that incentive was necessary to encourage the teaching of Islam. So the jurists gave a fatwa in favor of charging fees for teaching the Quran. So that's because it citing earth and that as basis. Then number 8, differentiate the following terms of juristic basis. First, neo-ijtihad, and then al-shasa, al-sharia, and then third term is talfiq. So dito na ako medyo nahirapan, although may mga nabasa naman ako about the terms and I encountered them before, but medyo mahirap talaga siya i-explain briefly. So first is yung neo-ijtihad. I cited Clark Lombardi in his book. He coined the term neo-ijtihad, which looks like traditional ijtihad, but requires that a person interpreting the Quran and Hadith give legally probative authority only to the rules that are found in texts of indubitable authenticity and are certain both in the transmission and meaning. So that's for neo-ijtihad. And then for the siyasa al-sharia, basically Lombardi said that this is statecraft in accordance to Sharia. So Lombardi posits that this style of statecraft requires conformity with two key concepts, that the law did not command people to sin and it advanced public welfare. And then yung concept of talfiq basically means when a person joins between the sayings of two mujtahid imams in his worship or business, whereby he produces a composed ruling which neither of the two imams agree with. So parang may ruling, for example lang po si Hanafi school and then may ruling ni Maliki. Pinagsama mo yon, Yun yung concept of talfiq. Meaning, makakabuo ka ng bagong ruling kapag pinagsama mo yung dalawang ruling nila. And not necessarily na basically yung pinagsama mong ruling is agreeable to any of the two imams. Yung ruling ng dalawang imams na yun. So, medyo controversial. Okay, and then number 9, explain the doctrines of ibaha, tolerance of the lawgiver as it relates to the exercise of the principle of al-siyasa, al-sharia. So, nirelate pa rin dun sa statecraft through sharia, and then this time yung ibaha naman, i-explain yung doctrine of it. So, again, I cited another book here. Ash Dallin referred to ibaha as giving liberty, but cited Noel Coulson, who stated that it refers to the tolerance of the lawgiver, allowing his creatures on earth freedom of action and behavior outside the area covered by his specific commands and prohibitions. So from ibaha itself, it is actually just tolerance of the lawgiver, but relating this to the principle of al-siyasa, al-sharia, I said that there may be a degree of tolerance in certain nations' practice or application of sharia. So this also stresses that there may be differences on how sharia is practiced in one country as compared to another, but this does not readily imply that there are wide differences in the interpretation of the Sharia from country to country. So, and then I recalled the differences of opinions among scholars and what should be our attitude towards it. This was discussed previously in the class naman. So, again, what should be our attitude if there is a difference between scholars? So if one belongs to the rank and file or has not studied Sharia knowledge and thus cannot distinguish between right and wrong with regard to scholarly views, then he must follow the fatwa of a scholar whose knowledge he trusts and who he believes to be trustworthy and religiously committed, whether he is from his own country or another country. And differences between scholars will not matter after that. So basically, nirelate ko yung differences of opinions dun sa differences of practices of Sharia from country to country. And then the last question for 1993, give 5 instances wherein polygamy is justified under Islamic law and jurisprudence and or considered lawful within the scope of its interpretation. Medyo napahugot ako dito doon sa PD 1083. Parang i-apply yung instances wherein polygamy is justified. So, citing PD 1083, I said, number 1, yung 5 instances. First, he can deal with them with equal companionship and just treatment as enjoined by Islamic law. And then number 2, he is seeking it only in exceptional cases or on exceptional grounds that is based upon meritorious, reasonable, and valid ground, or that is necessary and just. Number 3, an order of the proper Sharia circuit court authorizing him to contract a subsequent marriage upon the written consent of the former wife. Number 4, if the wife refuses to give consent to the proposed marriage, then there should be a court order allowing him. And then number 5, the man who divorces one of his 4 wives may marry after the expiration of Ida. So those are the 5 instances based on PD 1083. So, yun po yung 1993 Sharia bar. Mag-proceed na po ba ako sa 1995?
Yes. Proceed.
Okay
So, para isa na lang yung discussion later.
Okay po. So, the first question for the 1995 Sharia bar question. First is when and where were the first two sources of Islamic law revealed? Explain and how they were revealed. So immediately I thought of the Quran and the Sunnah as the first two sources of Islamic law. So basically, I just narrated how the Quran was revealed. So I said that the Quran was revealed during Ramadan in 610 Common Era to Prophet Muhammad. Allah caused the Quran to descend from the protected tablet on which it was written to the lowest heaven. In this revelation, all of Quran was sent down at one time to a station in the lowest heaven referred to as Bait al-Izza. And then the blessed night on which this descent took place is called Laylatul Qadr. And then from the lowest heaven, sections of the Quran were then taken down by the angel Jibril to Muhammad. And then this process of revelation continued over 23 years of Muhammad's prophethood. So that's the narration on how the Quran was revealed. And then I cited reasons why the Quran was revealed in that way in the period of 23 years. And then first is to steady the prophet's heart, to be gentle with the prophet, and then for gradation of legislation, to facilitate the preservation of the Quran, to deal with the problems as they arose, and then lastly to indicate the Quran source who is not the prophet. The second primary source is, of course, the Sunnah. And then I mentioned here that the Sunnah refers to the sayings and actions or deeds of the Prophet and actions of the companions which he tacitly approved. So I just defined how the Sunnah, what Sunnah is. And then I said that Hadith serve as a vehicle of Sunnah. And then I said that Hadith is significant to the Sunnah for it serves as a divine revelation because the Prophet's sayings and actions were primarily based on revelation from Allah and as such must be considered a fundamental source of guidance, second only to the Quran. Then, second significance, it serves as a tafsir or the explanation of the Quran. And then third, it serves as basis for laws. Fourth, it is the moral ideal because the Prophet's character and social interactions became prime examples of moral conduct for Muslims. And then lastly, it plays a major role in the preservation of Islam. So there is evidence to suggest that the Sunnah of the Prophet was introduced into the legal theory by the jurists of Iraq toward the end of the 1st century Hijrah. And then by the end of 2nd century Hijrah, the technical meaning of Sunnah appears to have become dominant. That is strictly referring to the Sunnah of the Prophet. So basically saying that there is also a concept of Sunnah other than of the Prophet. But I explained here after some time when people refer to Sunnah, they just specifically refer to the Sunnah of the Prophet. And then the second question, what is meant by the statement, the glorious Quran and the Sharia par excellence? I'm not sure how to answer the question, but I tried here by saying that the Quran is considered glorious and esteemed Sharia par excellence because it is the first source of the Sharia, and the ulama are unanimous on this. And then I cited that some are even saying that all other sources are just explanatory to the Quran. And then it is also deemed as the pure word of God and is thus a divine revelation or wahi. And then the Quran was reportedly not affected with the history of the Arabs or the events that occurred during the period of its revelation. And was therefore handed down in complete and original form since the time of the Prophet. And then the primary objectives of Sharia. So this was discussed to us in our class. So I just enumerated, but I cited here that Allah does not prescribe something upon His creations unless the maslaha that comes out of it preponderant or outweighs any harm if there is harm. And then Allah does not forbid anything unless the mafsada or the evil that results from it is preponderant or outweighs the benefit or good. So Maqasid al-Sharia refers to the objective of Sharia and is primarily based on the protection of essentials or al-daruriyat, the complementary al-hajiyat, and the embellishments al-tashniyat. And then proceeding, the al-daruriyat refers to the following: protection of religion, protection of life, protection of dignity or lineage, protection of akal or intellect, and the protection of mal or property. And then I added here, based on our lectures, some ulama included honor as part of the maqasid al-sharia. And the complementary interests or al-hajiyat naman on the whole supplement to the five essential interests, and it refers to those kinds of interests whose neglect leads to hardship of the individual or community, although it does not lead to the total disruption of normal life. And then yung third, yung embellishments refer to interests whose realization lead to improvement and the attainment of that which is desirable. So that's it for the primary objectives of Sharia. And then for number 4, state and explain the relations of the Sunnah to the Holy Quran according to the rules of the law embodied in the Sunnah. What are their respective Sharia values? So I explained here that the ulama are unanimous that Sunnah is a source of Sharia, and that in its rulings with regard to halal and haram stands on the same footing as the Quran. Companions have reached consensus on Sunnah being proof next to Quran in all Shari matters. So number 5, will there be a possibility that the rules of law embodied in the Quran will be in conflict with the rules found in the Sunnah? So this was also discussed to us. It was mentioned that during the lifetime of the Prophet and following his demise, the Sahaba or the companions eagerly obeyed the Prophet's instructions and followed his examples regardless as to whether his commands or prohibitions originated in the Quran or otherwise. However, there is a concept of naskh or abrogation of the Quran by the Sunnah. Albeit there is controversy as to whether this category exists kasi baliktad. Yung parang ang Sunnah yung nag-abrogate sa Quran. So those who affirm it give us an example of it, the verse on wills, wherein Allah instructs the believers as follows. I mentioned this before, yung sa bequest. It is prescribed for each of you to have a bequest for your parents and relatives if any of you nears death and leaves wealth. So this early law was replaced by inheritance laws and repealed by the hadith in which the Prophet said, "Verily Allah has given everyone with a right his rightful, so there is no bequest for one who inherits." So parang ina-abrogate nung Sunnah yung Quran. And then we proceed to question number 6. Ito yung parang isa sa dalawang situational questions. And then the question is, A and B are husband and wife respectively. B demanded divorce yung wife from her husband on the ground that she is no longer in love with him. and she does not want to be guilty of showing anger to him as it is prohibited by Sharia, and signified her willingness to return to him the entire dower she received from him. And then B, filed her case with your court. As a judge, what would be your decision? So basically, when I read the PD 1083, I noticed that there is a divorce by means of cool in Article 50. So it says that she may offer to return or renounce her dower or to pay any other lawful consideration for her release from the marriage bond. And then the court shall meritorious cases after fixing the consideration, issue the corresponding decree or yung divorce. So this is, sabi nila, equivalent no talak sa husband naman. And then another situational question. A is a father of 3 sons, B, C, and D. Because A likes B more than the other 2, he decided to donate 1/2 of his property to B. A comes to your court requesting to be a witness to the donation. And then what would be your action to his request? So I cited PD 1083 allowing a bequest to sharers and residuaries, but dapat may consent from other heirs, and the bequest does not exceed 1/3 of the decedent's estate. So there's also a hadith that was attributed to the Prophet when he said, "Bequest is not lawful for an heir unless the others or heirs give consent." So majority of the scholars agree to this requirement of a bequest to an heir. Also considered here is if the other heirs are capacitated to give their consent and that their consent were given freely and voluntarily. So pwede as long as it does not exceed 1/3 of the decedent's estate and may consent yung other heirs. So number 8, define Sharia and differentiate it from Hukam. So basically, this was discussed in the early part of our classes, but Hukum is in its literal sense means command, in its technical sense means rule. So Hukum is different from Sharia, however, because Sharia is the system of rulings, and Hukum is just the ruling itself. In a literal sense, the word hukum can also refer to the other rules outside of Islam. So the word shari usually follows the word hukum to specify a specific ruling under Sharia. So, and then I proceeded to define what hukum shari is. It is the communication from Allah relating to the acts of the mukallaf by way of a demand or an option or a declaration. So that's it for number 8. And then another question, define fiqh and differentiate it from usul fiqh. So again, this was discussed to us by Professor in the early parts of our course. Fiqh is concerned with knowing the ruling of a particular action and its basis, while usul al-fiqh is concerned to the general rules on rulings. So, and then I recalled yung analogy here, saying that fiqh is likened to a fruit, while usul al-fiqh is appreciating the fruit by knowing where the fruit comes from, how it is harvested, and who is qualified to harvest it. And then question 9, define ijma and explain its basis or justification. So naulit lang po ito sa 1993. So parehas lang din po yung sagot ko dyan. So ayan po, yung ijma. And then yung question number 10 naman, I guess sa kiyas. Ito pala, may nadagdag po, yung Sharia value of ijma. I added this as part of the question number 9, and then it reflects the natural evolution of acceptance of ideas in the life of the Muslim Ummah. It ensures the correct interpretation of the Quran and Sunnah. It enhances the authority of fools that are of speculative origin, and it represents an authority of its own right once it is established. So, yun lang yun nadagdag po. But basically, parehas lang dun sa 1993 question on Ijma. And then, ito po yung question 10, yung define Qiyas and explain its basis. So, parehas lang din po yung sagot ko. So, ayun yung basis. And then, I also cited yung 4 pillars of Qiyas kasi tinanong din yung as letter B. So, yun po yung sa akin. Sir.
Thank you very
Sige po.
much, no, Jonas. So, siguro yung ano lang, kayo, may comments ba, suggestion, or may question? May hindi ba klaro na concept? Anyone? Si Miss Sarip, si Mr. Sarip, tsaka si Miss Ayunan, tsaka si Attorney. Klaro ba lahat? Okay, so dun sa ano, no, dun sa questions mo, Jonas, yun lang ba ang hindi masyadong naging klaro sa yung neo-ijtihad, siyasa, sharia, tsaka yung talfiq?
Yes, sir. Ito sa tatlong yun po.
Okay, so dun naman sa ano, no, actually yung bandang huli na, yung sharia value rin. Sharia value, actually this term was coined by I don't know if it's kasi doon ko nabasa sa libro ni Justice Alauya, no. So actually ito yung translation to ng hukm syar'i, no? He translated hukm syar'i as sharia value. So dun sa question na sa ijma, ano ba yung sharia value ng ijma? So tinatanong din dito yung ano yung hukm syar'i niya. So usually ano ba pag may so once is it established, yun nga, yun sa pinaka last mo, nasabi, it's wajib, no, to follow it. Hindi na siya mapwedeng i-repeal din. Then dun sa questions, o dun sa concept, dun sa neo-ijtihad, siyasa syar'iyya, at saka dun sa talfiq. Medyo interrelated din, no? So yung neo-ijtihad, it is a new form of yun nga, neo, no? Form of doing ijtihad. But as other authors and other scholars have defined it, ang neo-ijtihad daw is a doing ijtihad, but yun nga, not necessarily that you have reached the qualification of ijtihad. So dito sa neo-ijtihad, anyone, no, can do ijtihad na kahit hindi mo na-reach yung qualification as mentioned by earlier scholars regarding yung ijtihad, paano ka maging qualified to do ijtihad. And some forms of neo-ijtihad, one form of neo-ijtihad is yung talfiq. Yung actually in partner siya dun sa takhayyur. Takhayyur at saka talfiq. Takhayyur is, as I have discussed sa ating mga klase, ito yung choosing, yung selection, no? Yun ang term na ginamit ng ibang authors, no? Selection, then yung talfiq is amalgamation. So ang takhayyur, so ito yung kaya controversial siya. Kasi yung takhayyur, you choose a ruling or a opinion not necessarily based on its the strength of its basis, yung ano niya, yung hindi doon dahil sa mas malakas ang kanyang basis o yung proof niya, bagkus you choose it because of other considerations. So for example, sa Pilipinas, no, because you choose it because it is in consonance with the Constitution of the Philippines. So ganito yung pagka-apply ng PD 1083 at yung mga laws, no? Na as long as it is not against the Constitution of the Philippines, yun ang naging pinakamalaking basihan nila. So hindi yung alin ba ang pinaka malakas o preponderant na opinion, no? Or hokum. So yun yung takhayor. No? So there's a vast number of Islamic law literature. So literature in Islamic law. So napaka rami ng choices mo. So you choose which is nearer or which is not against something. No? Iba yung consideration mo. Not necessarily ang consideration mo yung alin yung pinakamalakas ang dalil niya, pinakamalakas ang basis niya. So yung talfiq naman, as you have already yung answer mo. So amalgamation, you combine, no? You combine different rulings from different madhab. So yung binigay mo ng example, no? Kaya yung mga against dito sa practice na to, they always use this example, no? Kaya sabi nila hindi pwede, no? Ang talfiq. So ang binibigay nilang example ay yun nga, you combine the ruling sa marriage, no? In Hanafi school of thought, wali is not required, no? For a woman who has already been married before, no? Divorcee or widow, o yung babae na nasa tamang edad at pag-iisip, no? Yun ang sa kanila But actually ang correct na stand ng Hanafi is that yung widow or yung divorcee, pag mag-aasawa daw ito o papakasalan, no need for wali. So yun yung stand ng Hanafi school of thought, which is contrary to all other schools of thought. Then sa Maliki school of thought naman, it is not necessary or the marriage or nikah is still valid even without the presence of two witnesses. So yun. So ang isang binibigyan nilang example sa mga kontra dito sa talfiq ay yun nga. Sinasabi nila, pag pinagsama mo yan, you combine this, so ibig sabihin a woman can marry herself, no? Marry out herself without the wali and without witnesses. So which is totally not hindi to acceptable even sa sa both imams, no? Na yun. So yun yung sinasabi ng talfiq. And yung practice naman ng talfiq dito sa PD 1083 is that they have combined yung pillars and conditions. And we have mentioned that yung arkan o yung rukn arkan at saka yung shart, yung shurut, they are different. Pero sa PD 1083, pinagsama na nila yung arkan, shurut at saka yung wajibat, no? So if we take a look at the requisites, no, dun sa requisites of marriage, halo-halo to dito, no? Pinaghalo rito yung rukn, yung arkan, yung pillars of marriage, and also the conditions at saka yung mga wajibat, yung mga obligatory sa marriage. So hindi siya in this kind of practice of talfiq is actually not totally hindi siya unacceptable. Hindi siya unacceptable dahil wala kang ginawang walang haram na ginawa mong halal. At walang halal na ginawa mong haram. So it's okay yung ganyan na practice. Kaya this two concepts, itong two principles, yung takhayyur at saka talfiq, ito ay forms of neo-ijtihad, ay sinasabi ng ibang scholars, ng modern scholars, ay kapag ito ay naayon at walang nasagasaan na ruling sa Sharia o walang at ito ay na-implement ng maayos, ito ay acceptable. So yun. No? So basically yun yung neo-ijtihad, takhayyur at saka talfiq. Yung as-siyasa ash-shar'iyya as aptly described, yun yung statecraft. So ito yung governance. So ano ba yung relation niya dun sa neo-ijtihad at saka dun sa as-siyasa ash-shar'iyya? So mostly ang as-siyasa ash-shar'iyya actually yung pinakamalapit siya, closely related siya na Islamic principle ay sa maslaha mursala. Sa maslaha mursala. So mostly itong statecraft, ito yung pag-legislate ng mga batas, no, ng isang country. So as long as yung batas na nilegislate mo ay hindi nag-uutos gumawa ng haram, at ito ay for the benefit or for the maslaha of the public, ito yung magpo-fall under dun sa as-siyasa ash-shar'iyya. So it is also related to the tolerance dun sa concept of ibaha dahil gaya ng sabi natin, ang general ruling of all things, no, as long as it is not related to rituals, no, to acts of worship, all things are permissible. So, diyan siya yun ang relation nila. So, kaya yung sa siyasa syariya, you can legislate laws for the state, or policies para sa state, para sa kabutihan ng country, ng state, as long as it does not goes directly against any teachings or any principles in Islam or Islamic law. So yun yung as-siyasa ash-shar'iyya. Maganda yung mga questions actually sa 1993 na Sharia bar examinations. Okay, so any questions or clarifications? Wala na ba? Nandito pa ba? O nagkakape na?
Nagkakape na, sir.
So
Sir
hopefully,
Jonas, pwede, okay lang, sir, maghingi kami ng copy po.
sure.
Para maka-practice din
As long as pumayag si Jonas kasi sa kanya 'yan. So kung papayag.
Opo. I-post ko sa Messenger, sir.
Okay. So very good. Alhamdulillah na maganda yung at least na challenge ng konti si Jonas na pag-research pa doon sa mga ibang na hindi natin na-tackle kasi it is really impossible to tackle everything within one sem. Kasi ang Islamic jurisprudence nga ay 4-year course minimum, no? At yun nga, meron pang MA yan, meron pang PhD. Hindi mo alam kung alin ang lalabas na question. And yung in particular, yung siyasa Sharia, isang buong subject yan, no? Sa Islamic, sa college, no? Sa Islamic law. Bachelor of Islamic. So isang subject yan. So any other questions? Mr. Sarip, klaro ba yung mga concepts at saka yung sa questions, topics?
Yes, sir. Okay lang naman po. Wala naman po akong questions, sir.
Alhamdulillah. So si Miss Ayunan?
Wala naman din po, sir.
Okay. So alhamdulillah. So kayo, dalawa pa lang ang natatapos. So dapat makapag na kayo. Kasi yung deadline actually na submission nyo is 18. Kasi submission na rin ng grades. So, kayo kung anong gusto nyong araw. Pwede. Si attorney, pwede ba kayo ng Monday, ng 5 to 8? Actually, kahit gabi. Okay lang naman sa akin, basta okay sa inyo. Para lang maano natin yung requirement.
Okay lang, sir, sa Monday. Okay lang.
Monday na lang siguro, sir.
Okay, Monday na 5 to 8. Okay, so
yes, sir.
May oras pa yung ng iba na ng kanilang suggested answers. Okay, so kung wala nang question, so yun na, i-announce na lang natin yun ng Monday at doon na tayo, no? So 5 to 8 p.m. inshallah. Okay, so kung wala nang tanong, we will stop here, no? نكتفي بهذا القدر اليسير. فإن شاء الله نلتقي في يوم الاثنين. So we will meet إن شاء الله in Monday. So السلام عليكم ورحمة الله وبركاته. Keep safe everyone.
Waalaikumsalam. Allah. Thank you, sir. Jazakallah khair.
أنتم فجزاكم الله خيرا. So see you.
Thank you po,
السلام
sir.
عليكم.
See you po.
السلام عليكم.